Alright, continuing with Title 10, Chapter 12, Subpart, Chapter A, Part 275, Subpart 2, which is Oil and Gas Commission, Department, Environmental Energy, Subpart 2, Drilling and Procedures. Alright, definitions. Using the section added means the substance with a combination of the include with a proponent with a have some specify the purpose combined with a hydraulic fracture fluid chemical extract or CAS meaning with a chemical agency, chemical registry authority to collection and disclosure of chemical substance information, constant chemical constant discrete with chemical specific own specific name and identity such as but not necessarily the chemical extract specific number that is with the name of the atom chemical specific group of the element of the periodic table elements most commonly compound share physical with the chemical characteristics have the common DAQ, Department of Environmental Quality, hydraulic fracturing fluid made base fluid utilized with a particular hydraulic fracturing treatment. Hydraulic fracturing treatment means stipulating applicating hydraulic fluids and additive the force in order to create the artificial fracture formation purpose to improve the capacity of the produce hydrocarbons. OGC means the Oil Gas Commission. RCRA means Resource Conservation Act of the Title 40 U.S. Senate Code 6901. A tendency with a provision section shall apply with a new horizontal vertical wells amount with a hydroflexion during with a hydrofraction treatment of the wells exceed 10,000 feet bay areas of hydraulic fracturing fluid. For initial drilling permit issued on and after June 15, 2011, person applying with a permit drill the drill indicate the initial of the drilling application initial intent with a perform hydraulic fracturing treatment and operation provide information according with the subsection D with the section below. Intent of fracture stimulated with the well was not provided with the time of the initial drilling application permit holding desire to perform hydraulic fracturing treatment and operation. Send information required in accordance with subsection D with the section below with the view of the email, fax, mail, Oil Gas Commission office where the initial drilling permit was issued prior to commencement of hydraulic fracturing treatment operations. Application described in subsection C with the section shall include following the information proposed casing program demonstrated well have the steel alloy casing designed to withstand an anticipated maximum pressure whose casing will subject in the well with the well be vertical direction horizontal estimated true vertical measure production casing setting depth casing grade minimum internal yield pressure production casing producing proposed to be used in the well. Following information demonstrated that the well will have sufficient cement volume integrity prohibit the movement of fracture fluids uphold the various casing in the well bore annually. Proposed cement formations, minimum compressive strength, and estimated top cement with the production casing string with anticipated surface treating pressure range of proposed hydraulic fracturing treatment program. Proposed casing described in subsection D1 section shall be sufficient to contain the maximum anticipated treating pressure of the hydraulic fracture treatment not exceeding 80% of the minimum yield in internal yield pressure for such production casing. Surface casing in well is which produce hydrofracture treatment will occur with a B7 with a cemented with the surface depth of the corner with the Title 15 Code Arkansas Rules 275-213 and have sufficient internal yield pressure to withstand the anticipated maximum stress maximum pressure casing subjected to well. If during the drill surface portion of the well the prior surface setting of the casing with its freshwater fluid encountered permit holder gains knowledge of the freshwater encountered deeper zone was specified with the permit drill surface casing set forth and cemented at least 100 feet with the depth of encountered fresh water. If during setting cement with the production intermediate casing cement program does not occur with the submitted with the corner of the part with would cause reasonably prudent permanent holder question integrity with the cement program with respect to isolating zone hydraulic fracturing treatment with the movement of fracture fluids up to the whole various casing well bore newly permanent holder immediately notify the director of production conservation his or her designated in writing is practicable not more than 24 hours of the well. Reviewing the report, the director his or her designee may require bond log other cement evaluation tool to document cement integrity required additional cement operation other appropriate well work over efforts necessary to correct any cement deficiency prior to initiating hydrofracturing treatment in wells. Permit holder shall notify the director his or her designee via the email, fax, or other approved method minimum of 48 hours prior to commencing hydrofracture treatment on the well. If permit holder cannot provide notice within 48 hours to commencement, the permit holder shall provide written explanation of why notice and could not be provided. The permit shall provide notice in a manner described above as soon as the permit holder is aware hydrofracturing treatment has been scheduled. Permit holder shall monitor the casing annually, and that was diagnostic of the potential loss of the well bore integrity during the hydraulic fracturing treatment. Permit holder shall establish methods of the timely relieve any excessive pressure, avoid loss of surface casing integrity. Permit holder must have the written notice of the director, his or her designated any changing of the surface casing annual pressure would indicate the movement of fluid in the nullis. Pressure exceeded the rated maximum internal yield pressure casing shrink communication hydraulic fracturing treatment. Written notice should be delivered as soon as possible after the event, no more than 24 hours in event. With the following notification, aim to request additional information. Director, his or her designated request additional documentation. Well test determine the hydraulic fracturing treatment potentially endangering freshwater zones. Director and his or her designated may require appropriate additional cementing operation over the well work over efforts to correct any of the welfare. Pretending completion of the required operation and effort of the director, his or her designated may order suspension further hydraulic fracture treatment while other well operations. The director shall report in of the commission not mixed regularly scheduled hearing. Commission may take such of the further action deemed necessary appropriate within the circumstances. All non-RCRA Resource Conservation Recovery Act materials, fluids, site hydraulic fracturing treatment should be handled, stored in accordance with the Division of Environmental Quality requirements. Any special materials and fluids on off-site shall be reported to Division according to the applicable division requirements. The Recovery Conservation Resource Conservation Recovery Act exempt materials that are fluids infused on site with a hydraulic fracturing should be contained in leak-free tanks and other containment vessels. Any on-site spill of material fluids contain remediation after the commencement as soon as practical, and similar to report with the director, his or her designated 24 hours later. All fracturing hydraulic fracturing treatment flowback shall be with the handle of the transport and store with the disposal of the recycle in accordance with the applicable division Title 15 Code of Arkansas Rules 275-215, 275-503, 275-801 to 803. Following completion of hydraulic fracturing treatment, permit holders for purpose of the disclosure reported detailed information director, his or her designated hydraulic fracturing in the manner customarily reported presented permit holder over the time period specified in Title 15 Code Arkansas Regulation 275-205 follows. Maximum pump pressure measure of the surface during each stage of the hydraulic fracture treatment, type of the value of the hydraulic fracture fluid proponent used in each storage stage of hydrofracturing treatment. The calculated fracture height is designed to achieve that during hydrofracture treatment expects to make the TVD top of the fracture. This additive during the hydraulic fracture treatment is specified in general type as acid, biocide, braking, corrosion, inhibitor, cross linker, demulsifier, friction reducer, gel, iron control, oxygen scavenger, pH adjusting agent, scale inhibitor, proponent, sulfication. The names of all the names of the specific additive, each additive specified in the subdivision L4 of the section above utilized during the hydrofracturing treatment. The actual rate of the concentration each additive that expressed as in pounds per thousands of the gallons additive that would be expressed the percentage volume of the total hydraulic fracturing fluid additive. Permitted holders shall supply field service to the company with excluding pricing of the report regarding the hydrofracture treatment with a normal course of business satisfies some of the all foregoing information requirements. Permit holders shall supply all information received with the person performing the hydraulic fracturing treatment specified in the subdivision M4 of the section below. Each one permit holder case of the data that utilized during the hydraulic fracturing treatment and otherwise direct disclosed person performing hydraulic fracture treatment. Permit holders shall show the list of the chemical constitutivity associated with the chemical additives and number obtained in the additives. Provided, however, in those limited situations, specifically the chemical constitution and chemical added substance number is entitled within the whole trade secret under criteria section 42 U.S. Standard Code 11042A2 with the permit holder shall submit the director claim and entailment with identity with the chemical constitute withhold for the trade secret, provided the director chemical facility associated with the chemical constitute, identify any chemical constitute qualified as a trade secret under criteria section 42 U.S. Standard Code 11042A2 shall be the confidential director. Notwithstanding L8 with the section with above the authorized person information required by the state and federal law to be provided, healthcare doctor, nurse, all information of the healthcare professional doctor, nurse shall be immediately upon request person performing hydraulic fracturing treatment directly requesting healthcare professional doctor or nurse, including present with the volume of the chemical constitute associate CAS number, total hydraulic fracturing fluid and additives. Any person person performing hydraulic fracturing treatment in the state of Arkansas will be authorized to do business in the state of Arkansas, will be required to file organization requirements according to Title 15 Code of Arkansas Rules 275, 212, and include a link of the time entirely been in with the business of the hydraulic fracturing treatments. Disclosed to the director, his or her designee maintains separate material lists. All hydrofracturing liquids utilized during any hydrofracturing treatment in the state of Arkansas, all additives to be utilized during the hydrofracturing treatment in the state of Arkansas, chemical content of the CAS number to be utilized in hydrofracturing treatment in the state of Arkansas, provide, however, the limited situation where the specific identity of such chemical constitutes associated CAS number entitled to the withheld of the trade secret under the criteria set forth in Title 42 U.S. Code 110422A2, the person performing hydrofracturing treatment such as submitting a direct claim and entailment identifying such a chemical constitute with withheld with the trade secret to provide with the director chemical associated with such chemical constitute to identify chemical constitute qualified with the trade secret under the criteria set in 42 U.S. Code 110422A2 shall with the competent director provide permanent holder with the subject to perform a hydraulic fracturing treatment, lists hydrofracturing treatment utilized during hydrofracturing treatment, additive utilized during the hydrofracturing treatment, actual rate with the concentration each such additive utilized exceed with the pounds per 1,000 gallons per gallons per 1,000 gallons. Additives additionally additives expressed with the percent of the volume of total fracturing fluids additives so that the permit holder must comply with the obligation under section L of the section above. See a chemical constitute with associated CAS numbers so during the hydraulic fracturing treatment specified with the identity chemical constant associated CAS number entitled withheld with the trade secret in accordance with subdivision M3C of this section above, N1 subdivision M3C and subdivision L9 the section above shall authorize any person without holding prior required state federal laws provided healthcare professional, doctor, and nurse. All information required by the healthcare professional, doctor, and nurse should be supplied immediately upon request of person performing hydraulic fracturing treatment directly responsible, requesting a healthcare professional, doctor, and nurse, including percent of the volume of the chemical constitute with associated CS number, total hydraulic fracturing fluid, and additives. No permit holder should utilize services with another person to perform hydraulic fracturing treatment unless the person performing the hydraulic fracturing treatment is in compliance with subsection M of the section above. Alright, tubing. All wells should be equipped with a producing tubing. The bottom tube of the blowing wells should not be higher with the top producing interval. The top is perforated with the perforation not seen with above the top producing interval. All dry gas wells that don't require producing tubing provided surface casing shall be set within accordance to applicable rules. If the multiple gas zones are produced, authority commingled with accordance to Title 15 Code Arkansas Rule 275-407 shall be required. Alright, general leasing operation requirements. Definition purposes section crude oil tank battery means crude oil storage or other vessel commonly used for production, temporary storage of crude oil. DQ, environmental director means oil gas commission director, production conservation, EPA, United States Environmental Protection Agency. Gas well produced fluid storage tanks means for the tank vessels commonly used temporary storage fluid produced for the natural gas for the disposal. Lease means the tract of land under the agreement by an owner and a person for purpose of producing oil and gas allocating production him or herself the owners of the oil and gas rights under the tract of the land. Permit holder means an operator or a person who duly authorized to develop a lease on unit owners for the through the agreement has the right to drill the reduce the field with the reserve of the appropriate production him or herself the others. Produce wells means of the fluids produced with the generation of the crude oil production and separation process shall include crude oil, bottom sediment, all water regardless of the chloride content associated with the production of oil and or gas oil, well produced fuel, storage tanks, more tanks of other vessels commonly used with the temporary storage fluid produced by the crude oil per disposal. Oil well produced fluid storage tank means tanks or other vessels commonly used with the temporary storage fluids produced for the crude oil per disposal. RCRA, subtitle C, the Federal Resource Conservation Act of 1976, Public Law number 9458, and USW, U.S. Underground Source of Drinking Water defined in aquifer as portion. Supplies a public water system contains sufficient water ground quantity of groundwater supply. Public water supplies certain supplies drinking water. Human consumption contains fewer than 10,000 milligrams of total dissolved per liter, which are not exempting aquifer of the Title 40 Code of Regulations. Well identification: each oil and gas well should have a legal sign placing showing the permit holder well name and showing the permit oil gas commission records. Lease and a single well sign shall be placed for the associated tank battery to lease entrance. Every entrance of North Arkansas gas well sites have a legibly signed place entrance. Sign shall be the name of the permit holder with a list of the wells associated entrance with the section of the township with the name of the telephone number of the permit holder with his or her authorized agent to reach for the during an emergency. With the newly drilled well with the required sign should be posted 45 days for the cessation of the drilling operations. Any change of the correction of the information required with the post of the clone of the section shall be made with the well sign 60 days with the change that occurs. In case of transfer of the well ownership, 60 days effective the day of the transfer of oil gas commission from all prior signs, if they're not correct, errors shall be removed. Crude oil tank batteries, oil well produced fluid storage tanks, existing newly crude oil storage tanks with a well produced fluid storage tanks registered oil gas commission oil gas registration number. Registration should be reported to oil gas utilization information reported into existing oil gas commission from 6 monthly produced reports. All crude oil tank battery and oil well procedure fluid storage ring shall be transferred for the time associated well transfer utilizing approved notice well transfer forms filed on the oil gas commission. Each crude oil tank battery well produced fuel storage tank shall have a legible sign conspicuous on the near of the crude oil storage tank. Sign shall show the name of the permit holder of the oil and gas commission permit to operate the lease unit with the lease name and the section township and range telephone number which a permit and his or authorized agent during an emergency. All crude oil tanks and batteries well produced of the fluid storage surrounded with the contaminant dikes and other contaminant structures may be appropriate upon circumstances for the direct production and conservation. All common contaminant dikes and improved structures shall be constructed and installed within corporate subsection E of the section below. All crude oil tanks and oil well produced fluid storage tanks constructed effective with the dates shall be not located within 200 feet of each occupied habitable dwelling unless the current owner and structure have provided written waiver consenting of the construction of the 200 feet, in which the case the tank battery should be completely fenced in and to prevent unauthorized access. However, in no event with the tank battery constructed closer than 100 feet with the existing habited dwelling, 300 feet above the school, the hospital, or typical public with a defined Arkansas Fire Prevention Code, 300 feet with the stream of the river designated with extreme resource water with a scenic waterways, ecological sensitive water bodies defined in Arkansas Pollution Control Ecology Commission 8, Title 8, Code of Arkansas Rules, Part 21, within 200 feet of the other stream of the waterway, river, ponds, lakes, wetlands, unless approved with appropriate government agency with other bodies of the waters and indicated blue line designated 7.5 mile United States Geological Survey topographical map, unless also permitted to utilize additional contaminant measure for the required contaminant subsection specified in subsection E of the section above the prohibited director. All crude oil tank batteries, well-produced fluid storage tanks, and any other tanks shall not be buried below the ground. For all crude oil tank batteries and oil well-produced fluid storage tanks shall be maintained in leak-free condition. All open tanks shall be covered with a bird netting and another system designed to keep birds and flying mammals from landing on the tank. Gas well fluid and storage tanks and part of the such of the tanks are not buried with the ground. The occupied habitable within current owner structure and the written waiver consenting the construction closer than 200 feet with the close of the tank battery completely fenced, preventing unauthorized access. However, in no event with the tank battery by constructed 100 feet with the extent of the habitable dwelling, 300 feet in school, hospital, the other typical public use of the building, Arkansas Fire Prevention Code section, 300 feet for the stream river with the designated extraordinary resource water, natural scenic waterways, ecological sensitive water bodies defined in Arkansas Pollution Control and Ecological Commission Title 8, Code of Arkansas Rule Part 21, within 200 feet of the other stream, waterways, river, ponds, lakes, wetlands, unless approved by the appropriate governmental official agencies, other bodies, and is indicated blue line designated with a 7.5 mile United States Geological Survey topographical map, unless permit provided additional containment measure for the required containment specified in subsection E below that is approved by the director. 5A. All tanks containing with a producing fluid equipped with the receiver of the produced fluid shall be surrounded with the contaminant dikes and other the contaminant structures may appropriate with the under circumstances approved with the director. All contaminant dikes and other approved structures include within accordance with subsection E of the section below. Contaminant dikes or other contaminant structures. All crude oil tank batteries, all well produced fluid storage tanks, gas well produced fluid storage tanks surrounded by contaminant dikes, such as other structures appropriately under circumstances of the director prevent and allows us to protect life, health, and property until the exemption of Oil and Gas Commission filed with a notice of hearing, where contaminant dikes of the approved structure of the design have the capacity of at least 1.5 miles down with the largest 1.5 times the largest tank with a contaminant dike approved with the structural sound. Natural human made with the material with the utilized with the construction required with the contaminant dikes over the approved structure with the natural human material with the bottom of the contaminant air sufficient and perfectly continuous and fluid and resist erosion. Vegetation top outside surface of the contaminant structure shall be maintained with a not proposed fire hazard for the area with the contaminant dike. Other approved with the contaminant shall be kept free with excessive vegetation, stormwater, produced fluids, other oil, gas, fuel related debris, the general trash and flammable materials, drain lines, and 12 of the firewall purpose to drain storm water shall have the wear valve and shall remain closed and capped at all and not in use. Any fluids collected and spilled with the discharge of the contaminant structure to remove the practical use of the following proposal of disposal methods. Stormwater shall not be mixed with non-exempt Resource Conservation Recovery Act ways of the United States Environmental Protection Agency to drain with the contaminant source provided with the following conditions are met. The chloride content shall not exceed the applicable stormwater standard, but must be the events for the hydrocarbon sheen present. The discharge shall only take place during daylight hours. The representative of the permit holder must present with the during discharge unless otherwise approved with the director of the permit holder shall maintain with the record of each stormwater discharge according period of 6 months in which shall be available for review of the Oil Gas Commission. And the record shall have the location, quantity of the chloride content presence of the hydrocarbon sheen with the date of the discharge of the produced fluids have not been mixed with the Resource Conservation Recovery Act ways defined in the United States Environmental Protection Agency. Recycle the production equipment to remove the contaminant structure of the disposal of the properly permitted Class 2 underground injection control well. All storm wells produced have been mixed with the Resource Conservation Recovery Act defined in the United States Environmental Protection Agency shall remove the disposed in accordance with Arkansas Pollution Control Ecological Commission rules administered with the Director of Environmental Quality. Crude oil bottom sediments may be applied only if field lease roads on the following condition application such a manner that will avoid runoff of immediately adjacent lands of the water and state. Immediately found the completion application liquid fraction immediately incorporated with the roadbed with no visible freestanding oil. No lease roads oil more than twice a year. No lease roads shall be oiled during precipitation events over the bottom sediment. Should have the produced water content greater than 10% of the water by volume inject with the inactive oil gas well production, which is equivalent to opening packing with the purpose of the said injection packer to be set with a production casing at least 50 feet below the top of the production case, but not less than 500 feet below the base of the USDW injection over the bottom sediment not exceeding 45 days with each oven immediately plugged in accordance with the Title 15 Code of Arkansas Rules 275-208 with the director determine the field of the observation injection activity USDW injection activity shall see if the condition is corrected. Any residual produce fluids remain with the containment of the dike after removal of the required subdivision E5 of the section above the remediate plate in accordance with the Title 15 Code Arkansas Rules 275-222 with any spilled leak with the discharge of the producing fields escape of the contaminated dike should report with according with the Title 15 Code Acquisition Rule 275-222. Alright, one crude oil tank battery, well-produced fluid storage gas, well-produced in the storage tank gas is separated, remove the permit holder, remove all the above-ground piping fluid flow lines coming in the said tank for the separated cup, all below-ground piping flow lines, level and grade all soil portion contaminant dikes, remove it inside with all non-soil contaminant structural construction material with immediate hydrocarbon contaminated tank with a separated site, according to Title 15 Code Acquisition, Code Arkansas Rules 275-222. Liquid hydrocarbon and flue lines producer fluid lines. All fluid lines production and liquid hydrocarbons constructed with effective date of the selection should be buried at least 24 inches below the ground surface of the flue lines. Except for these burial agreements are approved with the directive of the following circumstance with topographical land use ground conditions to prevent effective fishing burial flow lines. Suspected presence with the numerous old abandoned flow lines in production field with the remainder of the burial new lines impractical will significantly increase the likelihood likely causing the discharge of crude oil for the old lines. In terms of oil gas lease surface owners agreement that prohibit the burial of flow lines. Flow lines are installed with the place and lease for the road right away. Flow lines from the well with the tank bed are entirely confined with the original direction of the line location. And all flow lines which occur if they're not buried and naturally drained, such as creek stream, the rivers, and intermittent stream of the ravines, are should be constructed in such a fashion the bridge drainage failure to protect the flow line damage due to the adequate support result of the potential discharge violation state water quality standards. The director shall have the authority to require that the flow lines exist on the effective date section replace barriers and constructed in accordance with the subdivision F2 of the section above, and to require visual approval above ground individual inactive abandoned portion of those abandoned flow lines to be removed, opening and sealed with the director fund with the base of field operation flow lines constant with the heads of public safety can reasonably expect the cause of damage environmental through leakage, spills, and discharge. No fuel lines transported producing water shall have the outlet valve and for the purpose of the discharging producing water in the place well with the origin authorized store to dispose point. Specialized valve installed for the purpose of venting trapped air with the after flow line maintenance is permissible. Any spilled leak of the discharge flow line shall be reported immediately in accordance with the Title 15 Code Arkansas Rules 275-222 with the natural production line gathering lines shall be installed in operation in accordance with the Title 15 Code 275-406 applicable Oil Gas Commission rules. Power lines, all power lines installed with the effective date section installed with the system manner to prevent contact with a vehicle or pedestrian travel. The director of the authority to require power lines is if the effective date of the section complying with the subdivision of the H1 section above the director find with the field observation power lines comes with the hazard to public health. Equipment in use of storage wellhead area should be kept free with excessive vegetation or product. Equipment include but not limited to separator, heat treatment, piping, compressors, and injection pump chemical containers shall be kept free of vegetation, maintained in all safe, good, and working condition. Use refined oil from the production equipment and pump jack injection pumps and compressors shall not be improperly disposed of the place in the storage tank containing the produced water. All used oil shall be disposed in accordance with the Arkansas Pollution Control and Ecological Commission Title 8 Code Arkansas Rules Part 81 Section 279. Excessive usable operational production equipment not integrally related to production activity and lease established drilling unit other utilized production area should not be stored any surface of the property unless the written consent with the consent of surface of the owner of the production equipment is located with the grant with a permit or the storage such equipment. Unless the equipment is to be designated by the permit holder to be the furniture of the lease, establishing drilling unit other unitized production area of the equipment and storage area shall be limited with the area close proximity to existing wells in production area and maintain kept free with excessive vegetation. Other trash and debris included are not limited to abandoned, unusable, or unrepairable junk tanks, treaters, tubulars, injection pump jacks, concrete, above ground pipeline flow lines. Any other general junk equipment and machinery shall not be stored on any surface property. Equipment owned by the permit holder. Remove trash and debris should be disposed of according with the Division of Environmental Quality and their state agency rules. Production pits are used in this section means either Earth's surface impediment, the human-made excavation dike area that was currently used for the temporary storage of producing fluid prior to disposal. Construction production pits other than the pits previously authorized the Oil Gas Commission orders are prohibited. All the other production pits existing effective date in section should be used with effective date of the section closed 90 days effective date of the manner section Oil Gas Commission accordance with all applicable state laws unless so in accordance with subsection J4 of the section below. Production pit existence is an effective date of the section may be not subject to disclosure in accordance with subdivision J3 of the section above. The pit is no longer used for temporary storage fluids produce fluids. The water quality in the pit is less than 1,500 with no visible sheen of oil. A written notarized authorization current surface the owner of the receiver the director requesting that a pit will not be closed demonstrating an acceptable alternative use of the pit determined not to require the pit to be closed. The director shall receive the current location of the pit relevant to the ongoing production of the operation in the area proposed alternative to use the public health and safety consideration potential agricultural recreation wildlife habitatual purpose of the director determined that based on the review of the information submitted by the operator surface the owner of the pit is not exempt of the pit should be closed 6 months by the operator of the corner of the subsection J3 of this above. Leaking permitted well where any oil, gas reservoir, or salt water is produced fluid and potentially leaking the USDW Determine the geological field investigation linking of the strip of the permitted transfer of the permit holder. The permit shall be plugged over the permit holder. Pending plug of the well, injection wells 1/4 of a mile radius. Leaking drilling hole shall be shut until the well is plugged. Leaking previously plugged well with an oil gas reservoir fluid salt water is potentially used leaking the USDW or to the server that determined geological field investigation well plugging the oil gas commission will replug with the original permit holder responsible for plugging the leaking well. Original permanent well that is no longer existing and cannot be located well shall be eligible to plugging the abandoned orphan well plugging fund. Pending the plugging of the well, injection wells of the 1/4 radius leaking well shall be shut until a leaking well is plugged. Alright, deviation test. Alright. Maximum point of well penetrated with producing formation shall be the unreasonable area with the vertical the down center of the hole shall be the deviation except for the following shall be deemed within unreasonable more than 3 degrees of the vertical down drawn from the center of the hole. The strip of the oil gas commission shall have the right to make with the required of the operator direct survey of the hole under the following circumstances. All of the case where the operator proposed to deliberately drill the direction well of the exemptional surface location and over the exemptional bottom hole location permit being issued with the offset of the required operator request of the directional survey. They agree the rating, pay all the cost expense for the survey, assuming liability risks associated with the survey, post a bond sufficient to determine the commission the survey against all of the costs of the reassociated survey. 3A, anytime when the by the order the commission is first to present with a substantial evidence of the likelihood of well with the drill of the other located should permit well with the direction of the unit boundary of the bottom location when necessitate increased penalty of the well production and allowable. Commission shall have the continuing jurisdiction except for the expense of the risk of the survey, such survey between the operator and the opposing party. Alright, vacuum pumps prohibited. Use of vacuum pumps of the devices for the putting of the vacuum in any of the gas or oil bearings from the prohibited except for the field of the vacuum pump through the January 1st, 1939. Otherwise, approve of the oil, gas, and chlorine of the subsection B of the section below. Administrative approval of the director of the product production conservation, his or her designee authorized approval of the application. Administrative approval of the vacuum pump with the other device for the purpose of the putting of vacuum in any of the gas oil bearings from the following condition. Application provided with the proof of the fields of the particularly with the depleted use of the vacuum pumps over the device for purpose of the putting of the vacuum in any of the gas oil bearings shall be otherwise necessary to prevent the waste. Application could with the detail of the plat maps indicating current well location and include with the drilling units of the lease within control pool of the notice of it has been given to all of the owners as defined in Arkansas Code 1572-102 with the dime and no objection have the receiver of the directive in accordance with subdivision B6 the section below. Each such application submitted form and a description of the director included with the name and address of each of the owner defined in the Arkansas Code 1517-102-9. Which each drilling unit which applicant seeks approval of the vacuum pump with each of the device purpose of the vacuum pump any of the gas oil pump stratum currently filing application. The application shall send to each of the owner subdivision B4 of the section above the notice of the application verifies it with the mailing affidavit saying of the name and address of the owners of the defined in Arkansas Code 1572-102-9 dated mailing. Ordinance of the defining Arkansas Code 1572-102-9 in accordance with subdivision B5 of the section above, shall have the right to object with granting such application 15 days of the receipt of the application by the commission. Each objection may be made with the writing file with the director, his or her designee. Timely written objection is filed here, provided by the application promptly furnished by the copy of such application should be denied with the application of the denied under section application filed with the application hearing according to the Title 15 Code of Acquisition Code of Arkansas Rule 275, 101, and 102 of the other applicable hearing procedures. 7A. Applicant may be referred to the commission determination for the director, his or her designee of the deemed necessary for the commission of the judge for determining purpose of protecting the correlated rights of all parties in order to prevent waste and other reason promptly up on such determination no later than 15 days after the receipt of the application. Director, his or her designee shall have the applicable written notice of the citation, citing reason for the referral of the commission determination. Application shall be denied. If the application is denied, subsection application may file with the application with a hearing in accordance with the Title 15 Code Arkansas Rules 275, 101, and 102. Other applicable hearings if the director is not notified of the application determined to refer to the applicant with the commission 15-day period according to the foregoing provisions. No objection received of the office of the commission 15 days provided with the subdivision B6 of the section. The application shall be approved. Alright, notice of fire breaks and blowout remediation associated spills of the crude oil and produced waters. The definition of the purpose of the second, the permit holder means the owner duly authorized to develop a lease the owner in thorough agreement has the right to drill, produce any field or reserve the purpose of production, him or herself herself. Notification permanent with the oil and gas with the prime condition, UIC with the class 2 with the class 5 with the brine, just roll with the well with the owner to operate with the tank storage tank with the other, receive with the drawer with the shop with the crude oil with the pursuits, receive with the drawer with the oil to the transfer with the flow line should immediately not more than 24 hours delay with the oil gas commission regional off with the vent with the occur with the telephone fast amount with the occurring and concerning all fires, blowout, spill, leak for the discharge, extra for the 1 barrel of crude oil, 5 barrel for the produced water for the oil should cover the lease facility. All noise, fire, blowout, spill, leak for the discharge for the provide with the commission regarding office to include the name of the operator, regional location, fire, blowout, spill, leak for the discharge, providing section of the town range, property to lease for the unit name, such of the report would specify the emergency step of the day, but they take in progress or remedy situation report with the reported blowout with the spill, leak with the discharge, the result of the spill with the discharge exceeding 1 barrel of crude oil, 5 barrels of produced water, and of the outside of the contaminant permanent holder should provide with the following required written indicate incident reform on the form to discover the direction of production conservation, amount of the crude oil produced water spill with the discharge of the area, extent of the spill, the discharge of the cover, the spill, the discharge of the proposed remediation effort spill, the discharge of the interstate, the interstate pipeline downstream of the custody transfer the refinement of the product pipelines not covered in the section under the jurisdiction of the violation of environmental quality, all crude production wall or spill regardless of the amount with the enter of the water with the shape of the defined Arkansas Code 84102 with the reported immediately the division of the portion of the spill with the enter of the water should stay with the end of the jurisdiction division of the remediation enforcement purposes. Crude oil spill remediation requirements, all crude oil spills that occur with the effect of the date with respect to them regardless of amount with the from the well with the flow line tank with the pits contaminated dikes subject shape of the permit required with the intake with the initiate with the following emergency response with the proceed with all the crude oils immediately after the spill with the curve with not more than 24 hours after the spill contain spilled crude oil at the earth and dikes of the booms of the contaminant per measure with the minimum of the amount with the area affected with the spill with the, if the spill surface of water if the spill shall be contained with the booms underflow dams removed expeditiously as possible. The further remediation requirement to determine the division in accordance with the subdivision A5 of the section above close shall be immediately appear with the impound free of the oil picked up and put in the lease storage tank with the remove of the site with the recycle with the meaning oil land shall be removed using the absorbent materials with the hand vial with all non-organic non-biodegradable absorbent material with the removed inside the disposal division permitted to waive the treatment disposal facility other disposable options allowed with the applicable state rule on site with disposal of the organic biodegradable absorbent materials such as straw, peat moth, maybe the deposit land spreading with the area over an area affected with the initial spill of remediated accordance in subdivision C4A1 of the 4 A1 through 4 of the section below with the contaminated area spill. Soil area affected spill will be remediated in place of the shell will be intended with the minimum of a feature of the, with a 13 to 13 to 13 fertilizer amount with acceptable fertilizer sufficient treat of the soil with 1.5 pounds per square yard. Limited to sufficient agricultural grade line effective with the area to order maintain a pH of 6 to 8 and pH soil mixture of less than 6 additional lime incorporated and increased above the pH of 6 titled depth of at least from 4 to 7 4 inches of no greater than 12 inches create with the soil and crude oil mixture with containing less than 5% of the total petroleum hydrocarbons. Following the completion initial tilling, water contained within soil moisture sufficient to promote plant growth, extremely dry soil condition exists, stabilize, minimize erosion runoff, storm water, prevent violation of applicable water storage quality standards. If the stored soil is effectively frozen on the previously saturated due to the rainstorm with the prohibiting complying with the subdivision C4A with the section above the permanent hold the stabilizing area, preventing surface runoff of the crew of leaving the effect of the area until the condition of the permit compliance with the subsection C4A with the section above. Soil is able to contain less than 1% of the TPH over the 12 months after the day of the spill. The director may recover the additional remediation action for the take with them by the operator shall include flushing of the air with the fresh water being collected with the spill with the UIC with the class 2 well with addition with the organic material with the peat, moss, and straw chemical treatment, additional decking of the soil with the absorbent material with the removal. If the soil with the absorbent material with the spill air with the cannot make TPH chain with the specified with the division C4A3 of the section above the contaminated soil with the removed offsite with the offsite of the disposal of the division permitted to landfill permitted to receive such waste or other division permitted surface water treatment to disposal of the required Apple State rule law. is spilled into the public ditch roadway with a visual of crude oil contaminated, remove the roadside ditch with the remove of the side of the corner of the subdivision C4E with the section above, incorporated with the non-road ditch and the spill of the remediated the corn subsection C4A with the section above. The permit holder required the submit on the request of 15 days of the spill of the recorded form prescribed by the director of the form, the topographical control of the extent of the spill of the proximity, surface of the water type of the spill of the current land, TBH contact and spill of the area, the 4 with exemption, explanation from the cover of the spill of the plan, efforts of the prevent and minimize the events of the future spill of the side of the B. Additional reports each of the 9 days and spill of the remediation completed with the approval of the director of the commission and after the notice of the authority to recommend with the approval of the remediation methodology above, approve alternative remedial methodologies and methods to achieve the same in the higher stream of the spill remediation. Producing water spill remediation requirements, all spill produced water which occurred with effect of the date with section walls, flow lines, pit tanks, and the contaminated dikes should immediately be not more than 24 hours with the contaminant, the earthen dike with contaminant mesh for the minimized amount of effectivity in the spill. All impound produced water that shall be picked up with the removed and decided with the disposal with the approved with the class 2 with the UIC with the well or recycled through with the permanent hot holders production process. The effect of the area shall be less than 50 pounds with the aggregated line with 100 per square feet with affected in the area total the depth of at least 4 inches. Based on the quality of air, some of the produced water spill with the proximity spill with the answer for the water feature with the note with the soil and land use air with impact of the safety. Director may require additional remediation to take for the permit holder of these additional may include flushing air with the fresh water should be collected with the disposal of the class 2 well with additional organic material, meat, moss, and hay and straw with additional chemical treatment, additional de-skying the soil with the soil removal. The operator shall require to continue the corrective action spill remedial efforts of the deemed complete direct basis site specific conditions. That was 222. Terminating naming common source 223. Wells shall be classified the common source of the supply, but they produce common source of the supply shall be determined with the name of the Oil Gas Commission provided with the event and with any of the person dissatisfied with classification. Termination application made with the Commission's classification. Termination deemed proper to the Commission were here with the determined same with the name of the Commission. So common source of the supply preference shall be given a common usage in the geographical name. Separate common source of supply with the same area of the preferable to name in accord with the producing formation. Takings to be rateable. Every person on the know now hereafter they engage in the business of purchasing, selling crude oil and natural gas for the trade shall purchase without the discrimination with one producer with against another and in the favor of one source of supply against another. For purpose hereof, the distinction shall extend between crude oil and natural gas purchased for the oil well, gas well, with those well, with the respectively defined in Title 15 Code. Arkansas Rule 275-103, the taking shall be deemed rateable with the purchase of the made with the discrimination between wells in which each separate classification. Alright, dual completion of the wells. Permanent well holders may complete the well such a manner with a permanent reduction of oil gas with the one formation with the tubing and oil gas separate from the formation and or with the tubing in case of subject to the following condition. Each well duly completed such regardless separate of the distinction of the production shall be taken and measured separately with the rules over the governing individual oil gas shall be strictly adhere to the permanent holder application department of the production for the complete gas well production gas of the form of the formation and or with the production casing the surface casing when the following conditions are met. Each application made with the prescribed by the director shall include the proper proof of the written notes owners of the operator described and defined in Arkansas Code 1572-109 governmental section with continuous release of the uncontrolled gas of the product produced. If control of the proof of the officer of the operators and owner of the defined Arkansas Code 1517-109 have the rights for the produce the same shall formation adjacent governmental section certification subject to all of the bins and separate cemented to the depth that is required in Title 15 CFR 270 Code Acquisition Code of Arkansas Rule 275-213 proposed zone with a produced otherwise not an economic limited reduction method potential. Offset operated with the owner's notice in accordance with the subdivision B1 section shall have the right to object for the grant and such application 15 days after receipt of the application Oil Gas Commission objection received the 15 days after the receipt application if the commission the permit holder may satisfy with the requirements of subsection B the application should be denied. If application is denied, permit holder may request to have the matter placed except in the established procedure on the document of the regular scheduled commission hearing. If the objection received the commission within 15 days of the receipt of the application by the commission and the permit holder is complying with the requirements of section B with the section application shall be approved. Or establishment of field rules as an application for purpose of the establishing field rules well establishing drill unit new reservoir pools except for the covered lands as specified in the Title 15 Code Arkansas Rules 275 to 230 and 231 or 231 should be submitted in accordance with Title 5 Code of Arkansas Rule 275, 101, and 102 with the applicable head of the procedure Oil Gas Commission 6 months with initial completion of the discovery of the well pool reservoirs after drilling 3 wells, whichever occurs first. Prior to receive the application for the permit to drill with the 3 wells on the same shore as supply of the exploratory area with the defined direct production of the conservation and shall be issued. B1 upon receipt of the commission of the application public hearing of the estimated fuel rules, well spacing, drilling units for reservoirs, additional permits made for the initial 3 wells be issued with the reservoir pool provided with the well permits. The application comply with the drilling units of the well provisions contained in here when the application permits may contain the issue with the hearing will help with the decision rendered. Commission may have to notice in accordance with the Title 15 Code Arkansas Rule 101 and 102. Other applicable hearing procedures granted the exemptions section provided such exemption create neither waste nor hazard conducive to waste. Alright, 227, the authorization director of production conservation immediate approval of the application for the exemption of well locations, and it's long. A director of production conservation his or her designee authorized to issue with the drilling permit of the well proposed with the drill with the being with the drill with the bedroom with the drill with the prior commencement from the production location of the well within the established drilling unit which failed to conform drilling unit setback distance required of the measure for the approximate center for the well bore over the boundary line of the Appleton Field rule. The Oil Gas Commission rules of the section only apply with the dry gas well with the drill vertically directionally, but it does not apply with the type of the dry gas well, the Wildcat well with the defined in Title 15 CAR 275-203 with the dry gas with explanatory as units established commission order. Oil gas condensate with the wells drill with the steam of the drilling units which were the well setback with defined with the distance drilling unit with the boundary defined with the land legal land description does not apply to the drilling units whereby the setbacks established or the meant with the Wildcat with the wells explanatory units established with the commission. Oil wells are uncontrolled field with the have standard well setbacks are specified in 15 CAR 275-203 apply to lease lines rather than drilling unit lines. B1 each such instance of the written permit issued with the uncontrolled field is not subject to the allowable reduction penalty with the allowable well would otherwise be entitled under provision of applicable field rules with the general well spacing rules and assessed with the multiplying by a fraction numerators width of the distance correct the feet with between the location proposed well the boundary well drilling of the unit with the well to be drilled the dominator of the which distance expressed the feet with the surface feet with the drilling unit otherwise required to be located at the proposed location encroachments of more than one boundary said unit, and the penalty imposed for the production allowable the cumulative of the penalties below the boundaries described in subsection B3 of this section below. If proposed location encroaches more than one boundary specified in subsection B and 1 and 2 with above, the reduction allowable should be calculated as follows. First boundary encroachment expressed in the setback footage specified by rule minus acreage for actual footage proposed well from the unit boundary divided by the setback foot specified by the rule plus the secondary boundary encroachment expressed second setback footage stated specified by rule minus actual footage of the proposed well of the unit divided by the setback footage specified by the rule penalty factor then penalty factor times the fully calculated allowable amount and equal the amount allowable to produce fully calculated amount minus amount allowed reduce in production allowable. Each application exemption location shall be submitted on the form prescribed by the director accompanied with the application fee $500 and included with the name of the address with each home of the district line in the Arkansas Code 1572-102 with the 9 with the drilling units of the purpose of the drill with the drilling offset with the boundary line with the casing of the well uncontrolled fields with the boundary with the mineral leaf with the offset and the leaf and the lace of the encroach over the proposed exemption of the well location currently the following with this application the occurrence with the section application shall send with the ordinance specified subdivision B4 of the section above the notice of the application form with the verifying such affidavit setting of the name of the address of all the owners for the dating of the mailing. 6A owners for the owner's notice of the corner for the subdivision B4 of the section have the right to project the granting of such application 15 days after the receipt of the application commission. Each objection is made in writing and filed with the director. A timely written objection when that file has been provided, application shall properly furnish copy of subject objection shall be denied. If the application is denied under subsection B6, applicant may request to have the application in accordance with Title 15 CAR 275, 101, and 102 with the other applicable hearing procedures. So I get regularly scheduled hearing with the commission of determination exempt with a non-additional application fee with the application referred to the commission determined with the direction to redeem the penalty imposed with the allowable such for such calculated to herein with the adequate offset with the bench application may have the other produced. Define Arkansas Code 1517-102 with the 8 with the reason for the drilling of the well, so if the exemptional location of the necessary for the commission made such determination purpose the protection correlative rights of all the parties promptly such determination not later than 15 days of the application. The director shall give the application written notice of the reason for the denial. Application of this section refer to the full commission determination. Application exemption location result of the directional drilling considered for the administrative approval in accordance with this section and provided no allowable authorized the commission furnished with the bottom hole of the directional survey each of the comments over the supply allowable was requested in such commission. In such case, if the directional survey is made available, the distance of the main point with the perforation of the common source supply the directional well of the drilling unit boundary that shall be given the calculated allowable with the direction of the notified of the applicant the determination application commission 15 days according with the foregoing provision no objection from the receiver of the office of the commission with 15 days provided with the subdivision P6 for the section application should be approved. Drilling permit you with the dry glass for the well is specified in subdivision A2 with the section alternative that include reduction of level of the penalty method for the outline subsection B of the section above the be requested. Each affected drilling unit had been previously integrated with the commission order the 100% of the lease for the incurrent with a held production at the working leasing interest owner of the effective of the drilling unit agree with the rating of the share of the proceeds with the well that encroaches the problem of the drilling unit boundary below the methodology determining percentage of the train cost production royalty among the affected drilling units may be administered by the authorized director of his or her designee method determining percentage of the train with the cost of receive the production from one or more separately with the measured wells as filed with the vertical of the directional drilled wells acreage agreed upon or extended with the perforated interval defined in Title 15 Code Acquisition Regulation 275-203 calculated each supplementary metered well and calculated area. The calculated area shall be based on estimated range of the perforated interval. Each calculated area allocated is assigned with each of the drilling unit according to the portion calculated area occurring with each of the drilling unit. Each such application utilizing the above methodology submitted form prescribed with the direction accompanied with the application fee of the $500 and will include the name and address of each of the owner Arkansas Code 1517-1029, which each drilling unit with the proper well the drill and completed the containment of the portion of the calculated area defined subsection C3A section above. Concurrently filing an application utilizing the above methodology application shall examine written authorization for each of the owners of Division C3C with the section above the application may be referred to the commission the determination of the director deemed necessary for the commission to make this determination purpose of the protective correlative rights and all the parties properties of the determination no later than 15 days after the receipt of the application. The director shall give the applicant written notice of the receipt of the reason for the denial application over the section referral with the full commission of the determination. If the director has notified the applicant of the determination of the applicant commission with a 15-day period with the foregoing provision, no objection to the receipt of the office of the commission 15 days provided in subdivision C3E with the section of the approve of the other drilling permit issued. Upon receipt of the drilling permit, the applicant shall give the other working interest party of the written notice of the drilling permit has been issued to the working interest party. We have not previously made the election. We have the 15 days after receipt have done notice of the whether make the election participate well of the deem the electing non-consent was subject to the non-consent penalty set out with the existing joint operating agreement covering the respective drilling unit. Following completion of the well with the prior to issuing the commission certificate compliant with the commence production final location perforated intervals submitted with the commence to the commission to refer to the proposed production calculated area occurring within each of the drilling units specified in subsection 3C3A of the section above. Alright, that was 227. Authorization Director of the Production Conservation Administratively approve the application exemptions for well locations. Alright, rules for hydrogen sulfide, H2S. Each operator can conduct the operation known with the hydrogen sulfide minimum concentration of 15 parts per million under atmospheric condition, 100 parts per million. More gas stream provides safeguard to protect general public harmful effect for the hydrogen sulfide. Director production conservation shall determine the areas covered by the section operation shall include drilling completion work over the producing gathering scope of the hydrocarbon fluids, natural gas fluid, produce associated with the bromine extractions, and the operation fall into the guidelines of the table of the gas for the system. The hydrogen sulfide constitutes defined as area with exposure to the mean of the area of the bend circle construct with the point with the shape of the trim of the radius of the exposure of the radius. Continue with the new plan means of the written document shall provide the organized plan and for the action with the alternating protecting the public within the area with exposure flowing with the accidental relief potential has the volume of the hydrogen sulfide public area that means the dwelling place of the business strip of the school with the hospital, school, bus stop, government building, a public road, or any of the portion of the public of the town, the city, village, or the other similar area with the populated any town public road, any with the federal, state, with the county, with the municipal street, with the road owned with the maintained with the public assets, with the radius of the exposure with the radius concentrated with the point with the shape of the starting point with the link calculated provide with the subdivision D4 of this section. General provisions. Each operation for the determinant of the hydrogen sulfide concentration gas mixture operations to the table vapor accumulation storage tank made with the industry except the colorimetric tubes. Each operator that immediately notify the oil gas in EX and release hydrogen sulfide gas measuring 15 parts per million over the greater than the radius exceeding 100 feet of the point of release includes any portion of the public. So this notification will be written with the reports convention for the 10 days of the incident. Each operation or for the convention conducting the answer for the activity operated with the provision section. For if there are all the other radius exposure for the radius for the Pascal for the Guilford equations. X of the radius exposure to hydrogen sulfide and the gaseous mixture established in the industrial method. Cube maximum valuable escapable cubic feet per day. Drilling well insufficient with a calculated the RO8 hydrogen sulfide may be exposed with the radius for the exposure for the 30,000 feet with the lesser assumed radius may be considered with the written request of the justifying the same with the indicators and some of the strategic location drilling will work over the production facility indicate with the wind direction all times safe with the upward any hydrogen sulfide presents storage tank provisions storage tanks to be utilized for the production operation operative with the atmospheric pressure for the vapor accumulation hydrogen sulfide concentration 100 parts per million should be the object subject to the following no determination radio exposure for the show between the storage tanks here and describe the lowering some of the post of the 50 feet of the alert with the general public the potential danger. All tank hedges shall be kept with the clove of the tank except for the necessary inspect with the gauge such tank with the all storage tank with the not reference not fence will require with the subsection E4 of the section will require to be kept and stored and locked with the hatch for the storage tank will not be inspected with the gauge. Entry should be restricted to essential personnel security measure for the in-storage tank limited city count town site with the refill exposure with the public all means the entry should be locked with the facility unintended with the hydrogen sulfide fumes the vapors recover with the vapor recovery with the end of the flare stock with a permanent pilot attached with the on a case-to-case basis invented permitted only the permit event with a review with respect to the distance or with the nearest public receptacle concentration of hydrogen sulfide volume to be released. Warning marker provision with the warning sign should be maintained with the street with the roads with the provide access with the facility with the marker shown as being installed with the pipeline with the located with the public area with the public road crossing along the public interval with a frequent event with the judgment operative with the public ride with the public incident rupturing the line excavation. Marker sign shall have the contain information of establishing ownership of the distance of the line, indicating the use of the word poison gas potential danger exists, satisfying the sign requirement of the following acceptable sign provides with the readable with a reasonable distance facility, existing sign with the install of the prior effect with the date of the selection, acceptable to indicate the existence of the potential harms, commercial control equipment and safety provision operator subject with the provisions to all safety devices, maintaining the operable conditions, establish safety procedure, design, prevent undetected continuing escape of the hydrogen sulfide safety devices should be tested annually recorded each test maintain drilling worker provision certification with compliance. 871 may be developed with intent over the drill with the well area with the depth known with the maintain with the hydrogen sulfide drilling operators require with the compliance provisions over the depth drill with 1,000 feet within the zone known with the maintained hydrogen sulfide. A variance of the complying with the depth of the may be approved with the written record with the justification of the however with the complete with the depth of it will not be less than 500 feet with the protect with the breathing equipment maintained with all personal site minimum hydrogen sulfide sensor with the derailing with the work over the rigs with the located with the rigger the bells with the bell nipple shaker sleeve with the and the butt pit with the other was approved with the detector blowout preventers well control system with trouble the pressure of the test initially a minimum of 3,000 per square inch of the gauge 75% for the internal yield pressure API casing property with the table of the side of the grave the casing being used whichever left thereafter all of the well controls shall be tested for reaching the compliance step of the commission not notified at least 4 hours of the initial blowout preventing well control systems test commission shall have the authority to verify the test and proceed with the deemed necessary for the secondary remote control blow control choke equipment that should be located with the rig floor of the safe distance of the wellhead operators shall install the choke manifold the mud gas separator flat flare line provides all of the method of lighting flare drill system stem testing drill stem testing hydrogen sulfide permitted with the daylight hour. The commission shall be notified 12 hours in advance of the intention of the conduct of the drill stem test of the containment formation of the containing hydrogen sulfide in the event of the hydrogen sulfide anticipated with the drill system test. All testing safety equipment shall be the location of the deemed necessary with the commission. All the gas produced for the test shall be flared. Flare system, pilot, automatic igniter. Every precaution shall be made with the public during the well test of the event with the resident with the radius of the exposure of the made effect with the drill stem test. Operators shall contact the Rose resident, inform of the pending actions, special consideration given the make resident of the chill with a medical ailment, the supervisory employee, the safety company representative, specifically trained by operation maintenance testing, all safety equipment and knowledgeable contingency plan, safety perceived on-site with the performance for the depth of the convincing long stream production casing of the during the time of the actual production work is being performed in a well. API publication RP49 and RP68 references the suggested guideline for the drilling work over the wells subject to the provision, contingency policy plan provisions operated with the whose operated subject to provision shall develop a written contingency plan complete with the requirements before the hydrogen sulfide operation began with the purpose of the contingency plan to provide the organized plan with the essential alerting of the protection public health of the accidental release potential health value of the hydrogen sulfide. Contingency plans activated immediately upon the detection of accident and release of hydrogen sulfide with the 15 parts per million greater than any point radius exceeding 100 feet from the point of release includes any public area. Consider with the might exist with each of the exposure and consider with the prayer and contingency plan and ensure they include instruction procedure for alerting general public safety personnel existing in emergency of the plan shall include procedures requesting assistance for follow-up action to evacuate public and area exposure. The plan shall include call lists which include the following as a local supervisor, professional commission, chief of the commission, county sheriff of the division, Arkansas state police, ambulance service, the hospital, the fire department, the contractor, supplemental equipment division, emergency management, the department of public safety, other public agencies intended the plan shall include plat detailing area of the exposure of the plat shall include with the location of the private dwelling, residential area of the public facility, the school, business location, public road with the other similar and public domain, reasonably expect with the exposure area of the separate list of all the phone numbers of the affected with the plat with this coming facility, including all the equipment location should be included with the commission should be notified with immediately with the contingency plan is activated. The potential of the contingency plan is filed with the plan should be available with the commission inspection at the well location. The plan should be retained in location which lends itself back best to activation of the plan. The plan should be kept updated and ensure the applicability. Each plan must be reviewed, updated annually. Copy dated plan submitted to the commission in January each calendar year. Training provisions. Each operator contractor provide appropriate hydrogen sulfide training for the employees will be on site, but all personnel must have possession current proof of the annual training. Training should include the hydrogen hazard character for the hydrogen sulfide operation safety equipment and life support system. First aid event employee exposure using or operation hydrogen sulfide monitoring equipment, emergency response procedure including corrective action, shutdown procedure, evacuation routes, and rescue methods. That was 228. Alright, seismic rules. The field seismic rules means any geophysical performance surface to land utilization certain instruments under the laws of physics respecting vibration, sound, termination below surface of the earth of the which containing the oil, gas, inclusive but not limited to preliminary surface acquisition, necessary permanent selection, marking slot holes, location necessary, clearing vegetation, slot holes, drilling, implementation, charging, placement of geophones, detonation, backfill shot holes. Seismic shot means for the specifically the project during the field seismic operation conducted with due diligence, the not achieve with a substantial area with the seismic operation indicated with the original permit. And B1, any person determining desiring performing field seismic operation state of Arkansas shall obtain with the permit each seismic shot for the oil gas commission with the prior to commencing field seismic operations. A copy of proof of the permit shall be maintaining essential recording using the seismic shot. The such permit should be valid 1 year for the date of the issuance. Each application should be made applicable with the form prescribed by the Director of Product Conservation. Each application filed with the accompanying application $500. Each application 2D seismic shot that should include the information on the map that include the seismic shoot area and indicate the proposed 2D seismic lines. Designate area 2 seismic line corridor within 2 seismic lines may be relocated to permit. No 2 seismic line corridor should be farther than 1/2 mile within either direction proposed location relevant to 2 seismic lines. Application with the area of the outer boundary of the 2 seismic line corridors, 2 seismic line corridor. Each application 3D seismic shots include information map that identify the seismic shot, include 3D project outline for seismic shot. Any 3D relocation 2D seismic lot, any portion of the 2D seismic lot seismic line corridor designated that they are increased the 3D seismic survey outline immediately reported to the record. Application officer required that the file amended application revised locations such as the 2D seismic lines. If the applicable, the application may also file with a request writing application. The information must be kept confidential period and not exceeding 12 months of the date of the filing with the original application. Subject applicant exemption include without limitation trade exemption with the general requirement of freedom of the information 1967 Arkansas Code 2519-101 intent sequence application and information map submitted with the release and extent of the requirement of the court of law applicable to state law regardless of the request should be confidential. So the applicant information map with the commission of evidence for the public hearing before the commission of judicial acquisition, and regardless of the such required of the producer, however, the permit holder shall retain the right object their admissibility, seek a closed hearing with a protective order. Their respect thereof, the application should be accompanied with evidence appropriate to the type of the financial assurance described in 15 CAR of 275-20D, and subject to these conditions listed, financial assurance be the least of $50,000, $250,000, provided the aggregated amount of financial assurance required with the application permits that expired permits issued with the pursuant section should not exceed $250,000. The amounts of financial assurance is determined by the director based on the not limited to the proximity to seismic shock of the populated agricultural area of the seismic, sensitive environmental areas, post-consumption commission enforcement history against the application financial assurance required field shot will remain effective 1 year following conclusion of all field seismic operation permit holder of the state of Arkansas. Upon review, the completed permit application shall be either the permit denied, permanent application denied, application filed with the hearing of the appeal director's decision in accordance with 15 CAR 275, 101, and 102 other applicable hearings. No entry shall be made with the person with the conducting field seismic operation upon the lands of such field seismic operation are to be conducted with the permit holder for is given the first notice 10 calendar days prior to commencement of field seismic operation. The notice shall be in writing given to either person with the certified United States Postal Service owners reflected with the tax record county and located with the mailing address identified such service owners in such records. 3. In an instance of the it can be reasonably associated certain with the occupant's residence of the residing on land and not on the surface of the owner such with the notice of the other given the occupants unless the known mailing address personnel notice can be reasonably given to any such notice of the occupant deemed and delivered personally deposed of the United States Postal Service postage prepaid say occupant mailing address land written notice of the even given them personally United States Postal Service operator reflected with the record of the commission producing well with the seismic shot area mailing address identified such operator said record with the name notice containing the name of the person with the entity with the conducting field seismic operation proposed location field seismic operation approximate date with the purpose of the commencing field seismic operation permit holder over the notified of the 5 business day with the commencement of the completion of each of the seismic shot of the vehicle utilize permit holder all agents come in contact with the show with the identified signs marking utilizing the letters and or members of the 3 inch of the and height 1.5 inch indicating the name of such agent. No shot over the distributed drill with a detonated 200 feet within a residence water well, oil, gas well, brine well, injection well structure without having secured the expressor of the written authority owner and other thereof. The permit holder should be responsible for the resulting change in accordance with the section. Written authority must be obtained with the owner, and if any charge exceed with the maximum allowable change the scale of the distance below. Alright, maximum allowable charge with weight with a 25-pound with unless the permit holder requires to secure with the prior written authorization record. All holes drilled with the field seismic activity should be properly backfilled with the soil with the other suitable material with obtained amount may be left over the hole for setting allowance of seismic source of the plate for detonation field seismic operation shall contain the additives accelerated by biodegradation thereof. There shall be handled with the care of the corner of the industry standard with the cap leave of the seismic soil with the failed to detonate, but it should be buried at least 3 feet deep. All vegetation clear of the ground with the purpose of the field seismic cavity clear of the component with the workman-like manner of the expire with due care, unless otherwise concerned with the surface of the owner of the permit holder the shall not cut down the trees measuring 6 inches or more than the diameter of the measure of the height of 3 feet of from the ground surface. There is no reasonable alternative to remove such a tree with the trees available to the permit holder. Permit holder compensates for the owner of the value of the such of the trees German enforced license with the shape of the Arkansas with excess of the routing and soil with the disturb of the root of the seismic activity shall be repaired, restore with the bridge of condition contour, extent, reachability, unless otherwise agreed. The permit holder shall, for the owner in writing, all fences removed for the purpose of the field seismic activity should be reported unless otherwise agreed with the permit holder surface owner in writing. All debris associated with the seismic activity shall be removed and properly disposed of. Any person who conducts the field seismic operations without having obtained with a permit, therefore, shall be subject to the civil penalty of $1,000 for each day the field seismic operation continues. Any person who does not fully comply with any of the provisions section subject to the civil penalty of $1,000 for each violation failure to comply with the provision of Arkansas Code 1571-114 amended with the other applicable rule of the commission resolve the forfeiture of financial assurance of the remedy the damage of the recovery of civil penalties according to the subsection T of this section above. In addition, any of the surface owners may seek to recover the damage of financial assurance filed with any surface owner seeking to recover the financial assurance of the damage of the caused by the performance of field seismic operations. The written notice of claim in the form describing the director of 1 year with the day of the expiration of the permit provided they have with such claim subordinate rights of the commission. Any of the receiver of the surface owner investigated the director of the decision for the revenue of the director of the decision satisfactory either the surface owner and permit order. Each party with a failing application in the hearing will apply with the director according to the Title 15 Code Acquisition Arkansas Rules 275, 101, and 102 with the other applicable hearing procedures. At the hearing, the surface owner must prove the actual damage occurred. Such damage was caused by the negligence permit holder violation section of the permit holder. C. Unreasonable except for the surface owner permit land holder of the applicable oil and gas lease of the agreement of the surface owner mineral owner concerning the use of the service of a seismic operation amount such damage if the commission found with the permit liable surface owner such damage the permit holder has 30 days for the effect of the day with the order to pay with the surface owner of the amount specified with the commission. Permit holder fails pay the amount specified with the commission surface owner of the director and initiate the bound for forfeiture proceeding described in Title 15 CFR 275 CAR 275-202K with the pay the damages for the commission provided however such amount should be subordinate to the right of the commission, and if the permit holder financial assurance is forfeited, the permit holder shall cease and field seismic operation and another bond same amount of original bond is filed with the commission same per for the original bond. That was 229 seismic scope, and we got about 3 to go. Alright. These are, it says establishing drill unit, gas production, conventional and unconventional services occurring in certainly prospective areas not covered in field rules, and alright. We're going to cut the tape there and call that the tape. I really don't care anymore. This has been a long reading. Yeah. So we did administrative and the drilling of the oil gas administrations.